resuming. We are resuming clause by clause. We are active. We are in order. We are live. The meeting is on. Different ways of saying that we're going to start working now on this. And I know Mr. Benson. Mr. Benson's at home, I think, or in his office somewhere. And I believe I was told that this would probably be your last committee meeting, and that you will be retiring. Is that correct from the political life?
At the end of December, I'm retiring.
Oh well, we wish you the very best in your endeavors and with your future endeavors, future projects. And I just wanted to mention that, and we wish you well, and thank you for being on this committee, which is doing important work.
Mr. Chair?
Yes. Yes, Mr. Damien, Mr. Kirk.
Thank you very much, Mr. Chair, and only because, of course, with the the tragedy faced by the passing of Mr. Carr and whatnot, and the nature of which the last few days of Parliament, I'd just like to, on behalf of Conservative Party members of the committee, thank Mr. Benson for his work in this committee, and since winning the riding of Calgary Heritage in, I believe it was 2017, if I'm remembering correctly, to thank him for his tireless work on behalf of his constituents. And I'm not sure that I'll have the opportunity to rise in the House, so thank you, Chair, for giving me just a brief moment to thank Mr. Benson for his tireless work for the people of his constituency, the City of Calgary, the province of Alberta, and this entire country. And specifically, I know we share a passion for seeing the energy industry succeed in the province of Alberta, and our world-class, environmentally friendly energy products be shipped around the world. So, Mr. Chair, on behalf of Conservative members of this committee, and I think I speak on behalf of the entire Conservative caucus, to thank you, Bob, for your work over the last number of years. You'll certainly be missed, and although I didn't have a chance to get to know you during the COVID circumstances, only having been elected in 2019, certainly appreciate the opportunities and the conversations that we've been able to have. And I think specifically after a meeting in Calgary, when we were able to have dinner together and discuss some of the challenges around the issues Alberta is facing, I know you're incredibly thoughtful and have worked very, very diligently. So thank you for that, and thank you, Mr. Chair, for the indulgence.
He joins in your remarks, in supporting your remarks, and we share those sentiments. So thank you, Mr. Benson, and all the best with your future endeavors. So we have Ms. Lewis substituting for Mr. Deltel. Welcome, Ms. Lewis. Nice to have you with us. And we'll pick up where we left off on Friday. We were at clause 3, NDP 7.
Monsieur le Président, vous avez pas quelque chose?
Excuse me, Mr. Chair, don't you have something to tell us? Okay.
It is what Madame Posé is getting to is that we will not have a meeting on Friday, and we will resume, clause by clause when we get back in January, unless we finish today, which I guess is always possible. It's always within the realm of possibility. Sorry, I just have to ask the clerk a question. Got it. Okay. Ms. Collins, would you like to move NDP 7?
Yes. And so the Bill S5 in Clause 3 be amended by replacing line 19 and 20 on page 3 with the following stances, or replace or reduce the use of animals.
Thank you. And in response to that amendment, I have a ruling which reads as follows. Bill S5 seeks to encourage alternative methods and strategies in the testing and assessment of substances to replace, reduce, or refine the use of vertebrate animals. The amendment seeks to extend it to all animals. But as House of Commons Procedure and Ethic and Practice, 3rd edition states on page 770, quote, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, and for the above stated reason, the amendment brings a new concept that is beyond the scope of the bill. Therefore, I rule the amendment inadmissible. And so I don't know if anyone wants to, pardon? There's no. So that's where we stand. We stand on that. I don't know if so. We'll now go on to.
Perhaps, Mr. Speaker, or Mr. Chair, I'm sorry. The difference between animals and vertebrate animals, I think, for the benefit of the committee, you should scientifically explain which animals are not going to be vertebrate animals here.
No, yeah. Unfortunately, I don't have to do that. Or I should say, fortunately, I don't have to do that. There's no debate on this ruling, so we'll move on. We'll move on to it's G4, I believe. Yeah, we go on to G4. Who would like to move G4?
Mr. Chair, this is an amendment I put forward. It's going to be dealt with further in the bill, so I'm not going to move this amendment at this time.
So, are you standing the amendment? Is that it?
No. I'm not moving it.
Oh, you're not moving it.
Yeah.
Period. So you're not moving it. Period. It's not just a question of not moving it at this time. Okay. Thank you, Mr. Weiler. Yes, Madame. Oui, Madame Posey.
Oui.
Yes, I would have a question on this. So, Mr. Weiler is not moving it today, but I didn't really understand that he would never move it because there's an amendment that I'd like to move that would follow from this one. So, will Mr. Weiler come back later with these definitions?
Je ne crois pas.
I don't believe so. I don't believe so.
Mr. Chair, if I might, Madame Posey, if you'd wish to move an amendment yourself, you're free to do that. It can build off of the amendment that was submitted in advance, or you could start from scratch. So it doesn't in any way impact your ability to do that, as far as I'm aware.
We're just going to pause for a second.
Merci.
Est-ce que c'est
So, was it a sub-amendment? No, it was an addition. Right. Apparently, this is the same thing as a sub-amendment. And so, given that the amendment was not moved by Mr. Weiler, we cannot move on to sub-amendments. Right, I understand. But my amendment that would have to do with definitions would be associated with clause number 4, so we're not there yet. Indeed, but we are going to clause 4 soon enough. But, so moving on to clause 4.
Oh yeah. So we didn't. Okay. Yeah. So shall clause 3 carry as amended? On division. Okay.
Have we passed clause 2 yet? That's the way.
We're past.
Okay. So we're coming to clause 3 here.
So we just passed clause 3 on division. Right. Okay. So now we go to clause 4. One Okay, so we start with PV3. Pursuant to our routine motion with regard to members from a party not represented on committee, this amendment is deemed moved. If Ms. May, would the sponsor like to make a brief explanation in support of her motion?
Thank you, Mr. Chair. I would indeed. And this is, I think, consistent with points made earlier in committee by members of committee, including Greg, the notion that we, in using a term, shouldn't leave it to courts to define how it's going to be interpreted later. So Partie Vert 3, PV3, offers definitions which are quite widely accepted in the field for the terms aggregate exposure and cumulative effect. I'm just given time. I'm not going to go through describing the definitions. They speak for themselves, but they're straightforward and quite widely accepted to provide background when the bill eventually needs interpretation. These definitions will be very helpful.
Thank you. Any debate? Anyone? Ms. Collins?
Yeah, I want to thank Ms. May for the amendment. I appreciate the definition for aggregate exposure, but I have concerns about the definition on cumulative effect. It reads to me to be too narrow. It excludes environmental effects and also narrows the definition to common mechanisms that target the same tissue. This kind of narrow definition has been problematic in the Pesticides Act and has meant fewer cumulative risk assessments on important topics like neonics. So I hope that we won't repeat the same mistakes that we've seen in that definition. So I guess I would I would say that I would propose an amendment to the amendment to take out the definition on cumulative effects.
Okay, so now we're debating the sub-amendment. And then we'll come back to Mr. Keurig, unless who would like to speak on the sub-amendment? Mr. Longfield.
Chair, I wonder, maybe Mr. Moffat could provide some technical support on this in terms of the cumulative effects and maybe more general the definitions within the Act around effects.
Can we just clarify exactly what the sub-amendment is, just so that we're...
Is the sub-amendment just to take out the paragraph on cumulative effects? That's it. That's what we thought. Okay.
Yes.
Yeah. Okay. So Mr. Longfield was speaking. Does anyone want to add or speak after Mr. Longfield?
It's both. Yeah.
No. So shall we vote on the sub-amendment? Yes, Mr. Longfield.
Sorry, I thought my question was on the sub-amendment. But it also, I think, in answering my question, might also help clarify where I would stand.
Yes, you did ask Mr. Moffat for an answer. I'm sorry, I apologize. Yeah, go ahead, Mr. Moffat.
Thanks. So happy to respond. I think that the government shares the concern about defining cumulative effect in two senses. One, we don't think it's necessary or appropriate to define it in the Act itself because it is a concept that continues to evolve within the scientific community, and defining it in the Act would lock it in and preclude us from being able to evolve on a policy basis. And then second, we also have concerns about the particular definition that is proposed, which is actually at variance with the approach that we've included in other parts of the bill, including in Section 68, which provides ministers the power to collect information on various topics, including on whether exposure to a substance in combination with exposure to other substances has the potential to cause cumulative effects. And this kind of information gathering would not be restricted to substances that have common mechanisms or modes of action. It would go well beyond that and look and allow us to look at the cumulative effects of from multiple completely different substances that may have different kind of mechanisms or modes of action, or even different effects. So this would be unnecessarily restrictive, and is also an example of why, in many cases, when a concept is being introduced that is evolving in science, it's best left to the government to define it as a matter of policy, clearly, publicly define it, put that definition out, but then let that definition evolve as science evolves. And then, if I might, just on the issue of aggregate exposure, the term doesn't appear anywhere else in the bill, so it's not actually clear what the legal implication of defining it would be.
Thank you, Mr. Moffat. Does anyone else want to speak to the sub-amendment? Mr. McLean?
I'm sorry, I got a little confused by Mr. Moffat's explanation there. So he's talking about this being more restrictive than the current interpretation of the bill as far as cumulative effect goes. And I thought this would be specific enough, but Mr. Moffat, you're telling this committee is that the definitions, the non-definition, if you will, would speak to the evolution of the way this could be interpreted in the scientific community going forward. Is that what I'm hearing from you, that by defining this, we are restricting the use of what cumulative effect will mean?
Yes, and apologies if I was not clear. I was trying to say two things. First, defining it in any way would preclude or could have the implication of precluding its evolution over time. Second, the particular definition that is proposed here is, in fact, narrower than our current interpretation of the term.
Anyone else? Okay, so, yes, Madame Posey.
Oui. Écoutez, je me suis ostinée.
Yes, so I argued about definitions last Friday. So what's important for me is that definitions are the same in French and in English. So if, I want them to be identical. So if in English we talk about defense, and it's, maybe Mr. Moffat could give you more explanations on this. So in the act, in the law, is the question of defense in English in the Canadian law, in the definitions? Or is it in the administration of the law? There are a lot of elements here.
You're on mute, Mr. Moffat.
I'm not sure, I apologize, I'm not sure if I'm going to be able to respond directly to the question. That neither term, aggregate exposure, nor cumulative effect, is defined in the statute at the moment. Cumulative effect and cumulative effects are referred to in a number of places in Bill S5, however. So it is an important concept, and it is one that informs our risk assessments and our risk management decisions. Aggregate exposure is not referred to in the Act or the bill.
Okay, thank you.
Mr. Chair?
Ms. Collins.
Just wondering if we could go to Ms. May, and my guess would maybe be that one of her amendments talks about aggregate exposure, and so in defining it might be important in case it passes, but I'd love to hear from Ms. May.
Ms. May, briefly, please.
It's Laurel Collins is correct, and I'd had a number of amendments, so I'm going through them now to see which ones need aggregate effects. One of them was already defeated, so that is moot at this point.
Anyone else before we vote on the sub-amendment? Yes, Mr. McLean.
I'm going to ask once again, Mr. Moffat, for clarity here. You would prefer to have this undefined, and I'm talking specifically about cumulative effect. If you can zero in on that term, please. You're more comfortable having this undefined. in this legislation, so it's wide open about how that definition evolves. This is what you see better for this legislation, and if so, please explain.
Correct. We believe that this term should be defined as a matter by policy. So we're not suggesting that Canadians should not be informed about the way government is interpreting and applying the term, but defining it as a matter of policy, again, would enable us to revise it over time as the scientific understanding of the kinds of ways in which cumulative effects are understood and need to be assessed evolve as science evolves.
Does that answer your question?
I think we should support Elizabeth.
Okay. Anyone else? Anyone else? Before we go to the vote, I'm going to call the vote. Yes, I'm calling the vote on the sub-amendment.
Mr. Dogood.
Opposed.
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Oppose.
Mr. Weiler.
Opposed.
Mr. Benson.
Oppose.
Ms. Lewis.
Opposed.
Mr. Kirk.
I'm opposed.
Mr. McLean.
Opposed.
Madame Posey.
Contre.
Ms. Collins.
In favor.
Yeas pour 1 nays contre 10 10.
Okay, so I believe we have Mr. Kurek who wants to speak to the amendment.
Yeah, thanks, Chair. I'm hoping to get some clarity, somewhat to expand, I suppose, on the conversation that we had during the sub amendment, because it's now especially relevant with both terms. So, just in terms of the reason why it seems like the government's position is that it would be problematic to have these definitions outlined within the Act, when certainly one of the concerns that we've heard from witnesses is that the lack of clarity is certainly concerning. So specifically regarding aggregate exposure and the definition that's provided, and but further on both terms as are being suggested by this amendment. So Mr. Moffat or one of your other colleagues.
The issue of aggregate exposure is a little difficult for me to comment on, because at the moment S5 does not include that term, as MP May has explained. However, she's introducing the term, or proposing the introduction of the term, in other amendments. I can't comment on committee process, but it might be useful for the committee to understand how those amendments would introduce the term and thereby make it potentially relevant.
Okay, Ms. Collins.
Yeah, just I was hoping to take out cumulative effects so that I can vote in favor of aggregate exposure, because I support the definition and I support Ms. May's amendments that had added it in. It does sound like at least one of the previous PVs has been defeated that had it in, so I think, yeah, I'll be voting against this.
Anyone else before we go to the vote? Okay, let's vote.
Any chance, oh, sorry, that called the vote?
Yes.
Because it occurred to me that the Conservatives had seen the point in having clarity around the language that is in the Act, cumulative effects. But might want to reverse the amendment and keep cumulative effects defined. But
we've called the vote. We've called the vote.
Well, the Conservatives can always make up a new amendment on the fly. I can't.
Yes, okay. Go ahead with the roll call, please.
Mr. Dogood.
Opposed.
Mr. Longfield. Ms. Taylor-Roy,
Opposed.
Ms. Thompson,
Opposed.
Mr. Weiler,
Opposed.
Mr. Benson,
Support.
Ms. Lewis,
Support.
Mr. Kirk,
Support.
Mr. McLean,
I support.
Madame Posey,
En faveur.
Ms. Collins.
Opposed.
Yeas pour 5, nays compte 6.
So PV3 is negative, and we'll go now to G5. Would anyone like to propose G5? Mr. Weiler?
Thank you, Mr. Chair. I would like to propose Amendment G5, which is under the reference number of 1213647, and it reads as follows: that Bill S5 in Clause 4 be amended by adding after line 28 on page 3 the following. Quote, healthy environment means an environment that is clean, healthy, and sustainable. And that's the amendment itself, and if I just may explain the rationale behind it. I mean, it begs the question what kind of environment would be healthy if it wasn't also clean and sustainable. But this amendment is based on testimony that we've heard from multiple witnesses, not least of which is the world's foremost expert on this subject matter, who's Dr. David Boyd, the UN Special Rapporteur on Human Rights and the Environment, who also happens to be a Canadian. And so this would make this act consistent with how the right is described in the UN General Assembly in a resolution that was passed just less than half a year ago, which Canada supported. And so it would ensure that Canada essentially practices what it preaches internationally. And it's defined here in the definition section such that it wouldn't need to be amended in every time we mention right to a healthy environment throughout this act.
Thank you. Would anyone, Ms. Collins?
I just want to thank Mr. Wheeler for putting this amendment forward. I think it is incredibly important, and I enthusiastically support it.
Mr. McLean?
Well, thank you. It is an interesting amendment, and I, thank one of my colleagues for putting forward a definition, something called healthy environment. But a healthy environment is an environment that's healthy is, not really explicative of what we need to accomplish here, with all respect. And an environment that is clean, healthy, and sustainable, all of which are, in my opinion, relative terms. And actually, I think we actually need to come to what we mean by a clean environment, a healthy environment, and a sustainable environment. I mean, this is more words on paper signifying no result at the end of the day. So I think it doesn't add anything to what's already there as far as saying healthy environment. A healthy environment represents an environment that is healthy, clean, and sustainable. Again, interpretive definitions. So I think it's redundant, and I will be voting against.
Anyone else? Mr. Kirk?
Do I have the floor?
I think I was recognized first.
Yes, I agree with my colleague's assertion that if we go back to the days of Maurice Strong in Our Common Future defining what sustainability is, we know that that's a very complex term. And I think that when we have terms that are looking to improve on environmental sustainability, we can't have them in a tautology. Like it's tautological to have these terms intertwined without defining exactly how each one relates to each other and how they enhance the environment.
Thank you. Anyone else? Mr. Kirk?
I'd ask if the officials have any, we're talking about definitions, and I know there's been some discussion related to definitions in previous amendments. So certainly one of the substantive changes that have been brought forward in this bill compared to previous iterations is the conversation around a right to a healthy environment. So I'm wondering if the officials have comments on on this definition, whether it's restrictive, whether it is in fact too broad, whether it has some consequences in the interpretation of how other clauses affect related to the bill. I think that would be helpful for the committee.
Would anyone like to take that?
I can start, and I'd make 2 points. The main one is that, notwithstanding the fact that many countries did support the UN resolution, and many countries have in fact codified various formulations around a right to a clean or a healthy environment. There is no standard approach to or understanding of the content and scope of the right. And indeed, when Canada voted in favor of the resolution, Canada expressly said that work is remains underway to develop a common understanding of the right. The second point I would make is that precisely because of the broad and general terminology being used, the amendments that we've introduced in S5 will require the ministers to develop an implementation framework, and to develop that implementation framework through consultation with Canadians. And the bill will require that framework to, among other things, clearly explain to Canadians how the government interprets these concepts and how it will apply those interpretations in the various decisions that are made under CEPA. That's why the bill itself did not include a definition and deferred the approach to defining and unpacking the concepts to the implementation framework.
Anyone else? Okay, I saw Madame Posé, Madame Collins, and Mr. McLean.
Oui, alors.
Yes, I think what Mr. Moffat just said is very interesting. In 2 years, there will be regulations. People have discussed all of this because we know that it's not a true right in the law, but I find it interesting to provide that detail because it provides evidence that we need definitions in this act. There aren't enough.
Yeah, just to Mr. Moffat, you had said that some countries had supported it. My understanding was that it was a unanimously approved motion around the right to a clean, healthy, and sustainable environment that passed this year, and that 150 countries around the world are implementing legislation around the right to a healthy environment. I'm just curious, any specific concerns, Mr. Moffat, you have about including the words clean and sustainable in this definition when we heard from Dr. Boyd, the UN Special Rapporteur on Human Rights and the Environment, that this was critical language.
Mr. Moffat? Our
concern, sorry, and first of all, apologies. I shouldn't have used the word some. You're correct. The resolution was widely adopted, recognizing the strong support globally for the importance of protecting, of providing for a clean and healthy environment. And indeed, the terminology that we've included in S5 reflects the emerging international terms. The issue that we have at the moment is one of not knowing precisely how the implementation framework will define the concepts, and not wanting to inadvertently set limits on our approach or require the approach to address issues that might be inappropriate under SEPA. So it's really a question of really that the approach is let's adopt the concept and then spend time discussing with Canadians exactly what it means and how it will be implemented under the Act.
Mr. McLean, yes. Well, is this a follow-up question? Yeah, okay, I'll go ahead.
Just wondering if there would be language to define this to include clean, healthy, and sustainable that would allay your concerns about limiting the definition. If it had said something along the lines of the healthy environment includes an environment that is clean, healthy, and sustainable, or includes but it's not limited to. I'm just curious how including the words clean and sustainable would cause problems in an implementation framework that I assume the government wants to include those concepts, given the recommendations we heard from Dr. Boyd and given the unanimous support from countries who take part in the United Nations.
That's a question for Mr. Moffat.
At this point, I think all I can say is that various countries have defined the concepts differently, have started with the same term of healthy environment or clean environment, and have then developed further definitions that are not all the same. And given that there isn't a clear and a consistent approach, the approach that's codified in the bill at the moment is again start with this general terminology and then unpack it through a public process to develop an implementation framework. I don't know if I can elaborate much more than that. I apologize.
Okay, Mr. McLean.
Follow-up?
Mr. McLean.
Just as a last comment, I hope that we can support moving forward with this language. It doesn't seem to me that it would limit the definition, but if it does, then I hope that people who do have concerns with it would maybe amend it to have language that would be open but still include these critical pieces.
Mr. McLean.
Thank you. And I'm glad that we talked about the implementation framework, because what lacks in anything the United Nations puts forward is the implementation in jurisdictions that actually have the responsibility to do something of this nature. So it is a bit of a paper tiger in that respect. But I do want to look at the conundrum here that we're talking about, because we are putting something on paper here that is a definition to be looked at going forward. So I want to address clean. Most of us here would say clean would represent a lack of bacteria, and healthy might mean a lack of viruses, and sustainable would mean exactly the contrary, because the environment isn't sustained without some viruses and some bacteria. Matter of fact, it's, as you say, Mr. Chair, it's one of the phyla that make up a large portion of the Earth, and yet that's not considerably clean to have a bunch of bacteria floating around the environment. At least most people in interpreting this definition wouldn't think so. So there's a conundrum I have, is this whole classification of each of these three words that don't really jive together at all when you actually analyze them and what people are going to interpret them to mean. Are we going to say, yes, this is clean, or yes, this is healthy, or yes, this is sustainable? Because the three don't exist together.
Ms. Taylor-Roy.
Yes, could we call the vote?
To this. So I will be calling the vote. I call the vote, Mr. Clerk.
Mr. Duguid.
Je vote pour.
For.
In favor.
Ms. Taylor-Roy.
En faveur?
In favor.
Thompson.
In favor.
Mr. Weiler.
I'm in favor.
Mr. Benson.
Against.
Ms. Lewis.
Against.
Ms. Vecchio.
Nay.
Mr. McLean.
Opposed?
Madame Posey,
En faveur.
Ms. Collins.
Enthusiastically in favor.
Yeas pour 7-7, nays compte 4-4.
So G5 is carried. We now go to BQ 2.1. Madame Posey?
Juste un instant, Monsieur le Président, je me cherche, là, BQ 2.1.
Le principe de précaution.
Just a moment, I'm looking for the right paper. After line 32,
One. Then PV4. Alors, allez-y, Madame Posey.
Alors, on va y
go ahead, Ms. Posey. Yes, I think you must have received the definition, which is the one from the Rio Accords. So that's following our discussion on Friday to define the precautionary principle as it is defined in the Rio Accord. According to which, in the case of serious and irreversible damage, the absence of scientific certainty should not be used as a pretext to etc., etc. So should I argue my case? I did so abundantly last week. On the English side, it is the Rio definition, but there's an error in the French version, and so this just corrects that error. Okay. Does anyone else want to speak to that? All right. Let's call the vote. Clerk?
Mr. Dogood.
Can we discuss this at all?
Oh, I just called the vote.
Did
They
ask
weren't
for-
ready?
Did you ask for discussion at all, Mr. Chair?
No.
Mr. Chair, I will vote to, what's it called? Suspend? Yeah. Vote to, or just ask to suspend. Yep.
After I've called the vote, I can revert.
I just, I think it's a good amendment, but I just want to get the clarity from the expert here, Mr. Moffat, on what this means exactly when we talk about Principle 15 of the 1992 Rio Declaration. Is that impacting the bill in any way?
I don't think at the moment. Sorry, we're just trying to work through the implications. We've just seen this amendment. The changing of the term prudence to précaution is not at all problematic. It's a clarification of a translation referring to the Rio principle again, and from a preliminary perspective, I think we all agree would not be a problem either, given that is the foundation for the way in which the precautionary principle has been interpreted by the government of Canada for the last couple of decades. I don't think we see any significant operational concerns.
Let me just ask. So, precautionary principle, as a term, means, so is defined as Principle 15 of the 1992 Rio Declaration on Environment and Development. Is that the full? So, Principle 15 will be what is defined. Like the two will be equal. So, whenever we refer to precautionary principle, it will have the full definition of Principle 15 of the 1992 Rio Declaration. Could you read that to us, what that full definition is, please?
I don't have that available. I'm not sure if one of my staff does. We can get it quickly, I'm sure. But I can reassure you that that Principle 15 has been the basis for the approach to the precautionary principle under CEPA from its inception.
Talking two different things, Mr. Moffat. We're talking about the definition of precautionary principle equaling Principle 15 of the 1992 Rio Declaration. And I'm not sure if it's, having not seen it, and I apologize, I'm not sure if that's all that's included in Principle 15 of the 1992 Rio Declaration. And that's where I'm seeking clarity.
So I can read, sorry, we're getting an echo. Is that better? I can read the Principle 15. In order to protect the environment, the precautionary principle shall be widely applied by states according to their capabilities, period. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. So the first sentence is obviously the kind of commitment by states. The second sentence is the definition that was introduced by the Rio Declaration, and you will remark that it is the precise definition that has been codified in CEPA.
Okay, and that's the full definition?
Yes.
Yes, sir.
Thank you.
Mr. Weiler.
Thank you, Mr. Chair. And I hate to nitpick here, but I wonder, is it common practice in this type of legislation that will directly refer to something like a principle in international environmental law such as this, or would it be better to just say what it is, in that where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. So it's a nitpicking maybe, but I'm just wondering if we need to include that reference, so long as we're sure that the definition itself is consistent.
Okay, that's a question to Mr. Moffat. Yeah, go ahead, Mr. Moffat.
The answer is that it's not standard practice, and indeed could introduce some element of uncertainty to people not familiar with the Rio principles. That said, the basic legal test for referring to external documents is that they need to be clear and they need to be available in Canada's official languages, and of course that's the case for the Rio Declaration. But to your more general point, it's not necessary, given that in fact the way the principle is codified in CEPA is word for word identical to the Rio Declaration.
Okay, anyone else? Ms. Collins.
Just noting that I, appreciate the amendment. I don't actually think we should be using the language from the Rio Declaration. I think, as has been argued for before, the Stockholm Declaration, as well as others, don't use the words cost effective, and the Senate purposefully took out the word cost and was instead moving towards just effective. And so, while I appreciate the motion, I will be voting against.
Madame Posey.
Oui. Ms. Posey. Yes, I just want to say that in Bill 2099, it's the English Rio definition. I just want to correct 20 years of error by including precautionary principle. What Ms. Collins is saying goes further, cost effective. I think we resolved that last time. So earlier on we were wondering what durable means, what healthy means. Now, there's a clear definition that has been used for 20 years in the English version. I'm just asking that we use the same clear definition in the French version. All right, perfect. Thank you. I think we're ready.
Perfectly fair to try to define and to use a definition, but I think what's problematic is that we are giving ascension to the 1992 Rio Declaration in this document, and I don't think that is appropriate to include an international treaty within this document. But the definition, I don't think is, in and of itself, may not be problematic, but it's just the inclusion of that declaration on the environment in the document.
Madame Posey.
Oui, je vais juste revenir pour...
Ms. Posey. Yes, I just want to come back to that because since 1999 in the English version, we've been using the Rio definition. The error is that in the French version, we talked about a prudence principle, but that doesn't exist. Economists use that term, and so this is just a correction that I'm trying to make so that it is the same in French as in English, because it's already in the Act. The Rio definition is there in the English version, so I'm just suggesting a correction so that the French version corresponds to the English version.
This is not a substantive amendment. This is really, I mean, semantics are important, but it is semantics.
So, I'm sorry, do we have proof, like any evidence that this is just, my understanding of what was said is that it is merely the precautionary principle, the term of using principle de précaution that is being changed to better reflect the accuracy of the term. Is that a correct understanding? That it's just a minor correction, that this principle already exists within the legislation.
Exact.
It's in the preamble? Okay.
Exactement.
Yep.
Anyone else? Okay, well, I think we're all ready for the vote, Mr. Clerk.
Mr. Dogood.
Oui.
Mr. Longfield.
Support.
Ms. Taylor-Roy.
En faveur?
Ms. Thompson.
Support.
Mr. Weiler. Mr. Benson.
Support.
Ms. Lewis,
Support.
Ms. Vecchio, Mr. McLean,
In favor.
Madame Posey,
En faveur.
Ms. Collins.
Opposed.
Yeas poll this 10, nays called 1 are.
So the amendment is carried. And we now move on to PV4. Ms. May, would you like to provide a brief explanation in support of your motion since it's already been deemed moved?
Thank you, Mr. Chair. Pursuant to the motion passed by this committee, I will exercise my right to explain my amendment, which otherwise I could have presented report stage in front of the whole Parliament, but for the motion. So quickly to say that we have in the current Act a new concept that was introduced on the Senate side of greater protections for vulnerable populations. They provided, we now have a definition at subsection 3, just section 3 of the Act, below clause, is part of clause 4. You find it on page 3. I'm inserting with this amendment a greater clarity around vulnerable populations to ensure that we are including children, women, including pregnant women. Well, you can read it for yourself, seniors, people who are exposed through or have a disproportionate risk due to socioeconomic status, race, national ethnic origin. In other words, it gives clarity to the term which is used just above where I propose we insert this amendment for greater clarity as to vulnerable populations. Thank you, Mr. Chair.
Thank you. Would anyone like to speak to this amendment, proposed amendment? Mr. McLean.
Thank you for definition to the member. In F, it says workers who use, handle, or are exposed to a substance or toxic substance. So effectively, anybody who's a worker is covered as under the vulnerable population. Is that perhaps a misprint? I'll ask the member first of all, please.
Thank you. No, there's within the existing Canadian Environmental Protection Act, substance is defined as is toxic substance. So this would not be a plain language meaning that any worker who touches anything is covered. It would be to those workers who are exposed to a substance within the meaning of the Act.
Ms. Collins?
Yeah, I appreciate the amendment put forward by Ms. May, and I just would like to sub-amend it, deleting the word include to read includes but is not limited to. Under 4, for the purpose of the definition vulnerable population, the individual in the group, and then instead of include, put includes but is not limited to. And just to speak to my sub-amendment, I think this is an important list provided here, but I don't think it is extensive. I think people who live in hotspots, I wouldn't want to limit our definition of who is included in vulnerable populations to this. But I do think it's important to explicitly state these groups.
Anyone else?
I just have a question for Ms. May. I know that Ms. May has spoke extensively on racialization and environmental racism, and I'm just wondering why it's just limited to one group, if she could clarify that for me.
Ms.
With
May?
your permit, thank you, Mr. Chair. Thanks for the question, Dr. Lewis. I'm echoing it there. Yeah, it's not to limit, it's just to provide greater guidance in the interpretation of the vulnerable population definition, which is now included in the Act. So what it says is a disproportionate race because of socioeconomic status, race, national or ethnic origin, color, gender, age, or geographic location. It's not a narrow definition, but it is to provide some precision in the interpretation of the definition that's currently in the Act. And thank you for the question.
Mr. Moffat had his hand up. Did you want to say something, Mr. Moffat?
Thank you, Mr. Chair. I wanted to, first of all, correct the assumption that it appears that some members have that this amendment was introduced in the Senate. This, in fact, has been part of S5 as part of the government bill, we consulted extensively on the definition of vulnerable population, and the feedback. I'd like to emphasize a couple of aspects of the feedback, and then if I can indulge the committee's time, turn to my colleague from Health Canada to elaborate. But 2 points. First of all, one of the main messages was don't limit the term. Again, I realize I'm saying this in many cases, but leave it open, leave it broad, and not enumerate a list so that it can be expanded over time. And second, we actually received very specific feedback from some Indigenous interlocutors who objected to being considered a vulnerable population. I appreciate that's not a consistent perspective from all Indigenous peoples, but some were very clear that they did not want to be listed. And if I might, I'd like to turn to my colleague, Mr. Caro, to elaborate on this.
Thank you, John. And indeed, Health Canada had the two concerns that were articulated by Mr. Moffat, notably that the motion could limit Health Canada's ability to assess subpopulation beyond those groups that have been identified by the motion, where new information regarding hazards or exposure may come to light with respect to populations that are more susceptible or highly exposed to harmful chemicals. And indeed, just reiterating the point made by Mr. Moffat, that we did hear feedback based on public consultations that some subpopulations would rather not be explicitly classified as vulnerable populations. So the current definition that's included in Bill S5 provides clarity with respect to the scope and breadth of vulnerable populations without citing specific subpopulations that can be defined through policy and implementation of the Act.
Ms. Lewis, then Mr. McLean.
I have a question for Ms. May again. When you use the word vulnerable populations, was that in reference because of the disproportionate effects of these populations? And is that something that you would consider changing, given the information that we heard about Indigenous populations? And in addition, would this amendment, especially Clause 4, would it be changed in any way if you added, but is not limited to, as our colleague had further stipulated?
Thank you for, may I, Mr. Chair?
Yes.
Yeah. Thank you for the question. And again, to Mr. Moffat's point, while there was reference to vulnerable populations, the Senate amendments substantially expand what will be occurring under future Canadian Environmental Protection Act policies and implementation around vulnerable populations. To answer the second part of the question first, Dr. Lewis, I have no objections whatsoever to an amendment that says, but is not limited to. And lastly, I would say to anyone who finds, any group that finds it a difficulty, this is a very specific definition that is around, this adds to a very general definition that is currently included in the Act, provides greater guidance, and is not overly general, but does not apply in all circumstances. It's a population when exposed to, or in the words of the Act now, in the Senate amendment that sub 3 bracket 2 on page 11, where there is a vulnerable population in relation to the substance. So it's not a general statement, your population is always vulnerable. It's a statement, your population is vulnerable in relation to a substance regulated under this Act, and that becomes one of the context setting elements to the question of toxicity, vulnerability, and whether the government needs to take steps. It's quite consistent. All the language that was adopted in the Senate in committee on S5 is very consistent with the bill that I know this committee has already passed without amendment, but Bill 226, my private member's bill on environmental racism. Thank you, Mr. Chair.
Thank you, Ms. May. Mr. McLean, and then Ms. Collins.
Well, thank you. And back to the member again, I'm just looking at the expansiveness of the definition here. You've got everybody under the age of 18, women, which include pregnant women, seniors, so everybody over the age of, at this point, 65, defined in Canada, Indigenous people of all ages, individuals with a medical condition of all ages, workers. So, and then in the Part G, it really is a repetition of many of these, including socioeconomic status, race, national or ethnic origin, color, gender, again. Would it be more instructive to say who this doesn't apply to? Because it does seem it's expansive enough. It applies to virtually everybody, number one. The second question I have would be, in F, we talk about workers. So we're talking about regulating workers, and I don't know this answer, but are we treading on provincial jurisdiction by putting some more federal regulations around a provincial workforce? As much as we might be doing the right thing, will it have some spillover effects on provincial legislation? Those are my two questions.
Is that for Mr. Moffat? Is that for Mr. Moffat?
That'd be to Mr. Moffat. I think the first question would be better answered by Ms. May, because she's here in putting forward. And the second question about the workers, I'd direct to Mr. Moffat. I can still ask her questions, right? No?
Oh, I've been asking her questions. My apologies. You've
Okay,
given me that latitude. Thank you.
Then if that's not the case, then I'll ask Mr. Moffat to answer
sorry,
that.
Mr. McLean. We can ask Ms. May a question, but we need a very, very brief reply. I mean, so it's sort of...
I hate these rules that you've given me, Mr. Chair, but I will go with them and give the shortest answer possible to Mr. McLean's question, if you will allow me.
Yes, but yes, briefly, please.
It does not apply to virtually anyone. It does not tread on provincial jurisdiction. The Canadian Environment Protection Act, its application have been upheld by the Supreme Court and would continue to be upheld within the four corners of the legislation in recognizing that this is what vulnerable populations could be in exposure to the substances as defined.
Mr. Moffat, did you have something to add, or can we go on to Ms. Collins? I think you...
I would just echo what Ms. May said.
Perfect. Excellent. Ms. Collins.
Thank you, Mr. Chair. And I just, for the officials, my sub-amendment was really to address the concern around limiting it to be includes but not limited to. And I was just wondering, specifically to the official from Health Canada, I was just reading a list on the Health Canada website that lists what could be considered vulnerable populations. And a lot of them are very similar to this list. I'm just, as I scroll down, says infants and children who may have greater exposure to certain chemicals due to behavioral reasons such as soil and dust ingestion, people living near industrial commercial facilities, blah, blah, blah. Indigenous people and communities who may be significantly impacted due to their close ties to the land or their consumption of country and traditional foods, individuals with dietary habits. It seems like Health Canada does have a list, or at least a proposed list, for vulnerable populations.
Is that a question?
That is a question, yes.
To Mr. Moffat?
I would they seem to be saying that we shouldn't actually create a list, and I'm just wondering, since we do have a list, a proposed list on the Health Canada website.
We're debating your sub-amendment, really. Okay, was that a question to Mr. Moffat?
Sorry, it was a question to either Mr. Moffat or the government official whose name I did not catch from Health Canada.
Carreau?
Mr. Carroll, but maybe I could jump in initially. And I think the issue here would be the difference between codifying a list in a statute, which is fixed until amended by Parliament, versus providing an illustrative list as a matter of policy, which Health Canada has done, as you've already noted.
In terms of the sub-amendment, in particular, just so that we create language that doesn't limit it, that explicitly says that we're including these things, but we're not limiting it to this list.
Not limited to. Oh, we
language.
want feedback from Mr. Moffat. Yeah. Go ahead, Mr. Moffat.
Yeah, I actually think that current drafting approaches and consistent with the way in which statutes are being interpreted in the courts suggests that that language is not necessary, and including is intended to be read as including but not limited to, as one uses
Okay,
in
so
normal
we
parlance.
don't need that language, is what you're saying. Yeah. Okay, Mr. Weiler.
Thank you, Mr. Chair. My reading of this amendment is such that it's quite a vast range of people. It essentially includes everybody as being a vulnerable population, with the exception of men ages of 18 to 64 that are non-Indigenous. So it's I understand subsection G, which really is what this is about, which is individuals that are at disproportionate risk because of exposure. So I have an issue with saying that all other folks other than that group that I just mentioned being vulnerable. And I think that's the reason that I have a problem with it, so I'll be voting it against.
Okay, but we're voting on the sub-amendment. So are we ready to vote on the
Mr. Chair,
sub-amendment?
can I withdraw my sub-amendment?
Yes, yes. Can you do that? With unanimous consent, you can. We have unanimous consent from Ms. Collins to withdraw our sub-amendment? Okay, it's
And Mr. Chair, can I provide a different sub-amendment?
Yes, apparently you can.
Wonderful. So instead of include, put may include. And the intention behind this is to provide greater clarity and also to address some of the concerns that Mr. Moffat raised around some Indigenous individuals who wouldn't want to be necessarily included in this.
Okay, so
list.
do we need to debate that, or can we go to a vote on this new sub-amendment? Yeah. Go to vote? Okay. Mr. Clerk.
Mr. Dogood.
Opposed?
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Ms. Lewis.
I support.
Ms. Vecchio.
Nay.
Mr. McLean.
Opposed.
Madame Posey.
Contre.
Ms. Collins.
In favor.
Yeas pool 2-2, nays compte 9-9.
Okay, so the sub-amendment is not carried. And are we ready to vote on the amendment? I think we are. Go ahead, Mr. Clerk.
Mr. Dogood.
Opposed?
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Opposed.
Mr. Benson.
Opposed.
Ms. Lewis.
Opposed.
Ms. Vecchio.
Opposed.
Mr. McLean.
Opposed.
Madame Posey.
Contre.
Ms. Collins.
In favor.
Yeas pool 1R, nays compte 10-10.
Okay, so PV4 is negative, and we now move on to PV5. It's deemed moved. Ms. May, would you like to make a brief
Yes.
explanation?
The principles that are put forward in Partie Vert 5 are already in the Act in various places, and this is to provide a definition. So definitions are included in PV5 for intergenerational equity, non-regression, and polluter pays. And where non-regression is not in the Act, it is useful to have the definitions in place, as scientific advances may mean that the government continues to want to amend the Act in future. Thank you.
Would anyone like to speak to that? I don't think so. So we'll go to the vote.
Mr. Dogood.
Contre?
Mr. Longfield.
Opposed.
Ms. Taylor-Roy.
Opposed.
Ms. Thompson.
Opposed.
Mr. Weiler.
Contre.
Mr. Benson,
Opposed.
Miss Lewis,
Opposed.
Ms. Vecchio, Mr. McLean,
Oppose.
Madame Posey,
En faveur.
Ms. Collins.
In favor.
Yeas pour 2, nays contre 9F.
So PV5 is negative. Should we adopt clause 4 as amended? Would anyone like to speak to that? We amended for it. Okay, so seeing as no one wants to, we're going to vote. We're going to vote. On division? Okay. On division? Sounds good. Now we go on to clause 5. Nous sommes rendus à l'amendement G6.
We're at G6, and I have a short text. If G6 is adopted, PV6, BQ3, and NPD 10 cannot be moved since those 4 amendments amend the same line. So does someone on the government side want to move G6? Mr. Weiler.
And that I know there's some active discussions happening amongst all parties with respect to this clause. I'm going to move to have this clause be stood and for us to return to it after we've gone through some of the other clauses.
Everybody in agreement with Mr. Weiler's? He wants to stand clause. No, he wants to stand G6. The whole thing.
You can only stand the whole thing.
Oh, Mr. Weiler wants to stand clause 5. Yes, but apparently you have to then stand the whole clause. The legislative clerk says the whole thing.
Yeah.
Can we suspend just for a
Yes,
moment?
we may. moving that we stand 5?
So I move that, and I understand we're going to vote on it then?
Okay, so, but I have Ms. Collins, I believe, wants to speak. No? Okay. Okay, unanimous consent, so we're going to go to the vote on clause 5? No.
No vote.
Consent.
Yeah.
We checked with all the parties, if you check the room. So
You're standing it
No
down.
opposed.
We're going to vote on it.
Nope.
No.
Oh, we're standing it, okay.
standing it down, there
Got it,
appears
okay,
to be
okay.
unanimous
Okay,
consent.
I
if
understand,
you-
I understand. But shouldn't I still,
No, we don't go to
we have unanimous consent to stand it down, we go to 5.1, okay.
You go to 5.1? Oh, okay.
Okay, 5.1 we have. Let me-
Mr. Chair, I'm sorry, does that mean that amendment PV6 is good before being heard at all, and we'll come back to it later?
Yes.
Okay, thank you.
So we go to 5.1 and G.
7.
Yes, I know. G7. Oops, where's G7? Can't find G7. I have G6. 31. Oh, yeah, okay. Right. Okay, so G7, who would like to move that?
Mr. Chair, I'll move that.
Okay, go ahead, please.
It's moved.
I mean, go ahead. Do you have anything to say about it?
I think it's straightforward, Mr. Chair, and I would open the floor to commentary, but then I'd be doing your job, so. Someday, maybe.
Madame Posé.
Oui,
Yes, once again, in the French, it says contents of the registry.
donc.
So, shouldn't it be content of the environmental registry in French? We seem to be missing a word. Do we need an amendment here to correct an oversight?
So that's a question for Mr. Duguid then, I guess?
I don't have an answer. Maybe
Mr. Moffat can tell us. Do we need, Mr. Moffat, do we need in the French version to add the adjective environnemental, registre environnemental, or is it just intentional that it only says registre?
That the registry has been in the Act since 1999, and I can't tell you why, but it has been referred to as in this way since then. So registre only in French and environmental registry in English. So this is just retaining that consistent or that inconsistent approach. So I don't think it creates a problem, but I appreciate that the wording is different in French and English.
Okay, merci. Alors, d'autres interventions?
Any other remarks? Yes, Ms. Posé. I just want to wrap my head around this. I don't want to move an amendment like you did for the precaution principle. Now, should we add this? It is a mistake, right? It is an oversight, or should I move a motion or an amendment? Well, it doesn't seem to be an oversight, says the chair. It's been the case for years and years. Well, then it should be corrected, shouldn't it? Just like the principle of precaution, the same applies here. Well, but what I'm being told is that the word registry is everywhere in the bill, everywhere. So if we change it in one area or in one section, well, then this will have a domino effect and it'll become really complicated. But it doesn't prevent you per se from moving an amendment. It doesn't mean that it will carry, but nothing prevents you from moving the addition of the word environmental. but it will have ramifications across the board. Mr. Chairperson, listen, we're having the same discussion as we had last Friday, are we not? I'm going to remain calm and reposed for the moment. Now, if you look at the English version, 13.1 states environmental registry, and in French, registry. Just registry. Which registry? This is a mistake that dates back to 1997. Why can't we correct it? We did so for the principle of precaution, so why can't we do it in the case of a registry/environmental registry?
D'autres interventions?
Any other comments before we proceed with the vote? Yes, just a moment, Mr. Chair, if you would. I'm being strongly advised to ask the question, would this amendment delete everything on page 28.4 until, because it says here by replacing, etc., etc., and this would conclude on line 3, so it would delete everything along those lines. Well, hold on a second. You're not talking about the registry. No, this is on another point. Another point. Mr. Muffet, would you like to chime in and respond to that particular question? This would lead to a lot of deletions in the bill as it stands.
J'ai une réponse, madame.
I have an answer, Ms. Posey. Good. We can now deal with this once and for all. Now, if you look at the section Part 2, public participation, then registry for the protection of the environment. And after that section, when the word registry appears, it refers back to the registry of the protection of the environment. So the problem would be is addressed, isn't it? The problem is solved. This is just a matter of being parsimonious. Well, hold on, but why isn't it the same in English as in French in that case? Why is there the shorthand version in French but not in English? I understand what you're saying, Ms. Posey, but it's implicit. It's understood. But now you're wanting to raise a second point, unless I'm mistaken. Yes? And Mr. Muffet, the floor is yours in response to Ms. Posey's other question. Could you repeat the question, perhaps, Ms. Posey? Well, yes, indeed. The Mr. Duguid amendment is very far-reaching. He referred to page 4, line 25, right through to page 5 to line 3. And I just want to make sure that that is what was indeed said and what the ramifications of that would be.
This question is better posed to the clerk, but indeed the amendment would delete all of those lines that are referred to.
Yes, it would. But Madame Posey is asking what that means substantively for the bill. Does it?
C'est exactement
Maybe
ça,
Mr.
That's right, Mr. Chairperson. Substantively.
What the purpose of G7 is? Basically asking what the purpose of G7 is, or maybe Mr. Moffat.
So, perhaps I can help. So when SEPA 1999 was passed, it enumerated this list of documents that needed to be that the law required the government to include on the registry. In Bill S5, one of the things the government has intended to do in multiple places, including in the registry, is to increase public access to information. And so this amendment, while shorter, in fact expands the scope of documents that the government would need to publish on the registry, whereas previously it only had to publish the items listed in the lengthy list of provisions. Now it requires at a very high level to publish all notices and documents published or made publicly available by the minister. So it's now a much broader requirement with respect to the kind of information and documents that we will need to publish on the registry. That's the substantive implication of the amendment.
Ça répond à votre question, madame?
Does that respond to your question, Ms. Posey? I see. Good. Sir.
Response. I think the amendment does the opposite, doesn't it, Mr. Moffat? It means filing less documents, if I'm correct. The question, Mr. Moffat, and then I have a follow-up, Mr. Chair. Mr. Moffat?
That's not our interpretation. Maybe I can turn it over to my colleague, Laura Farquharson.
Ms. Farquharson?
Sure. Okay. So there are a couple of things that this change would do. The first is there was a reference in the amendment that the Senate made to a database. And so this is to eliminate that reference. Because that's like there are several search engines that are used to find documents, but that particular language may not be how we do it all the time. And so then the other revisions though that were made were to take out those long lists, you're right, and to require the more general requirement to publish documents that are relevant. Then the other change that was made was so in the sense that as Mr. Moffat said, that it's broader in the sense that it now includes documents published or made publicly available by the ministers or either minister, whereas before it just had minister.
Okay, thank you. Do you have a follow-up question?
Yeah. My follow-up is just the B part of that, replacing lines 8 and 9 on page 5 with the following. Registry is maintained. We say registry is publicly accessible and searchable and is in electronic format. What's the difference in the amendment we're making here? I'm unclear. It seems to mean the same thing to me.
So I'm just trying to find which part you're looking at. If this is about being accessible electronically, it's to replace that language about database, which is a very specific way of providing information.
So please explain the difference to me, because we're talking about a registry. So the old wording says registry is maintained in the form of a publicly accessible and searchable electronic database, which seems to make sense to me. And the new one is registry is publicly accessible and searchable and is in electronic form. So tell me what the difference is in the nuance of those two statements, please.
I mean, I think literally database may not be how you use it. You might, I mean, somebody said blockchain. I'm not sure that we would use blockchain for this, but there may be other ways of providing the information than a database. Like literally, it's the database.
Okay, thank you.
Okay, any more before we go to a vote on 5.1? Is there anyone else? Doesn't look like it. So we'll go to the vote. Madame Posey?
I just want to make sure. Well, 556, parentheses 1, requirements, the minister may, and then it has I'm wondering if everything's covered there. Is that being covered by the amendment?
Donc une substance ou un groupe de...
A substance? I'm sorry, I'm on the wrong page, says Ms. Posey. My apologies. So, page 4. There's I, process, decision, assessment regarding a substance under a provision of the current legislation. Would that remain or would that be struck? And the II, all international instrument to which Canada is a signatory and that would apply to this substance. Because there's some things that are interesting in the case of each substance. Ms. Farquharson, did you understand the question? Yes. Ms. Posey is saying that this would be included in the scope of the amendment, wouldn't it? I'm sorry. I'm hearing quite a loud echo. Well, the second part.
To which Canada is a signatory that applies in respect of that substance, that would not appear in the registry. And I guess I would question the value of that, since the way that Canadian law works is that whatever is an obligation internationally has to be implemented through domestic law. So that's how you know which instruments apply, and you would see it in, for example, a regulation under CEPA that might prohibit a substance that had also been, Canada had agreed should be prohibited under an international instrument. So that is not there any longer. And as for the
it's not there any longer, but it's implied and it will.
Yes, it would. Yes, you'll see it in other
regulations
ways.
and other
yes.
ways. Bon, à votre question, madame.
Does that respond to your question? Can we vote on it then? It would seem that we can. Mr. Clerk, on 5.1, please.
Excusez-moi.
I'm sorry.
Non, excusez-moi, on parle de...
We're referring to G7. G7. Mr. Dewitt, your amendment, we're voting on it. Mr. Duguid.
Avec enthousiasme.
I vote enthusiastically in favour.
In favour.
Ms. Taylor-Roy.
En faveur.
Ms. Thompson.
In favor.
Mr. Weiler.
In favor.
Mr. Benson.
In favor.
Ms. Lewis.
In favor.
Mr. Kirk.
In favor.
Mr. McLean.
In favor.
Madame Posey.
En faveur, mais moins enthousiaste.
In favour, but not as enthusiastic, because I would like to see environmental registry. Well, it's implicit, says the chair, and we wanted to be economical in the wording. Well, in French, yes, but not in English.
Sorry. Getting punched.
Sorry, Mr. Chair, did you call my name?
No, the clerk did.
Okay, great. I didn't hear. In favor.
Yeas pour 11-11.
Bon. Shall clause 5.1 carry as amended? On division. Shall clause 6 carry? On division? Okay. Now we go to PV7.
Monsieur le Président.
Mr. Chairperson, yes, before PV7 is moved, given the scope of the work that the Green Party has engaged in vis-à-vis this clause, well, could we agree unanimously to give Ms. May more time? Ms. May said in the House that she'd been working on this for years, and I take my hat off to her because we can see this borne out in the work, i.e. these amendments. So could we accord more than 30 seconds? I'm going to call for a unanimous consent, says the Chair. Well, Ms. May is going to be able to explain, and justify her amendment, so there'll be some latitude given there. But I've understood what you've said loud and clear, and that is that we would give Ms. May more time to speak, given the length of the amendment. And I take that under advisement, but we will start by calling on Ms. May to explain her amendment in summary form to begin with. Well, thank you very much. And I'd like to extend a big thank you to my colleague, Ms. Posé from the Bloc Québécois, for the idea of giving me a little bit more time, because I'm in a rush because of the committee's motion. That's the only reason. This is a substantive thing.
Let me just give the factual context and background. I think members of committee will know that the section of the Act this amendment replaces is a comprehensive one. It puts forward the ways in which an individual can pursue an environmental protection action. It is significant that in decades, Section 22 has never been used. It is cumbersome, contains too many obstacles, and has never been used. So this, and I want to thank senior lawyer Joseph Castrilli from the Canadian Environmental Law Association. I confess that the two of us have been working on this act. I worked on it before it had first reading back in the 80s when I was in government. But this is an attempt to improve significantly, especially now that the act purports to create the right to a healthy environment, but with no mechanism to enforce that right. This is a gift to the government, to Liberals, to all of us to have an act that can work. So let me just explain briefly that section PV7.
Very briefly, please, because I have a
I know. I've taken 1 minute and 35 seconds.
No, go ahead.
I'll take no more than 20 seconds more to say that this amendment includes the ways in which an individual can proceed to federal court, the ways in which an individual can put forward the right, the way a court deals with that request for relief. It also puts forward a comprehensive set of defenses, and also for those who would worry that this opens floodgates or in any way creates frivolous amendments, Section 22 of this amendment very specifically allows a court to dismiss any action that's frivolous or vexatious. In other words, this is a complete scheme, a comprehensive framework for the full enforcement of this act that is fair to all and will work in the public interest. Thank you, Mr. Chair.
Merci, Madame May.
I should announce that PV7 would create judicial recourse that is not provided for under Bill S5.
Edition states on page 770, and I quote, "An amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill," end quote. In the opinion of the chair, and for the above stated reason, the amendment brings a new concept that is beyond the scope of the bill. Therefore, I must rule the amendment inadmissible.
Just a very quick comment that it's so unfortunate that the government didn't open up Section 22. This is such a critical piece of the bill, both in terms of enforcing the right to a healthy environment, but also the chair knows that enforcement in SEPA is one of my interests and I think is a critical issue, and I do hope the government will tackle this as soon as possible. I just want to thank Ms. May for putting this forward.
Noted. Thank you. We now go to PV8. Ms. May.
I would assume it would also be within this beyond the scope because it is a tidying up and deletion of a section replaced by the amendment you've just ruled out of order.
Indeed, that would be the ruling from the chair. The amendment seeks to amend Section 29 to 33 of SEPA. And again, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act unless the latter is specifically amended by a clause of the bill. So it's going directly to try to amend SEPA where, as I understand it, this issue is not mentioned in S5. So that's, yes, unfortunately, it's out of scope as I see it. So we now go to PV9. Ms. May, PV9.
Sorry, Mr. Chair. I'm just mourning the last passages. Sorry. Let me get to PV9. Again, it's a repealing a short section of the Act at the existing section section 38. The rationale for that, as briefly as I can, is to ensure that the framework, again, the framework introduced in the previous amendment would make this part inconsistent. So again, I think it falls subject to the same ruling as before.
It does. So the amendment seeks to amend Section 38 of SEPA, and to quote from House of Commons Procedure and Practice, 3rd edition, on pages 771. On page 771, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act, unless the latter is specifically amended by a clause of the bill. Since Section 38 of SEPA is not being amended by Bill S5, it is therefore my opinion that the amendment is inadmissible. That was PV9. And now we are at NDP 11. Ms. Collins, would you like to move the amendment?
Thank you, Mr. Chair. And the amendment, again, is looking at paragraph 2 to be, and really, I think, as Ms. May articulated, it is essential that we address the enforcement mechanisms in SEPA. The fact that no one has ever used the citizen enforcement is, in my opinion, egregious. I sincerely hope that the government will address this in short order, and I'm incredibly disappointed that it was not included in this bill.
Okay, thank you.
I have a question.
Debate. There's no debate because of the ruling. Yeah, but we haven't gotten to the ruling yet, so there's okay. We have a very good legislative clerk. He's way ahead of me. But the amendment seeks to amend sections 22 and 29 of SEPA. Again, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act unless the latter is specifically amended by a clause of the bill. Since sections 22 and 29 of SEPA is not being amended by S5, it is therefore my opinion that the amendment is inadmissible. So we go now to clause 7.
Mr. Chair?
Yeah.
Just as this is my first time going through clause by clause on a government bill, and with utmost respect for your chairing, if I were to challenge the chair, is it, the process is that everyone votes on it? Is that correct?
Yes.
And
debate.
Yeah, again, with the utmost respect, I would just like the committee to be on record about not opening up this section.
So we'll go to the vote, the challenge to the ruling.
The vote is on shall the decision of the chair be sustained. Mr. Dogood.
Yes. Oui.
Mr. Longfield.
Yes.
Ms. Taylor-Roy.
Oui.
Ms. Thompson.
Yes.
Mr. Weiler.
Yes.
Mr. Benson.
Yes.
Ms. Lewis.
Yes.
Mr. Kirk.
Yes.
Mr. McLean.
En faveur.
Madame Posé.
Contre.
Ms. Collins.
Against.
Yeas pour 9-9, nays contre 2-2.
Okay. So, Mr. Weiler, you wanted to say something?
Yeah, if I may, just very briefly, I think these are some very important amendments that were brought up, and obviously they're out of scope. at this time. But I think that these are things that have come up quite a bit with witnesses in the course of our meetings. And so similarly to how the Senate did when they were concluding their study, they put a recommendation that these issues be addressed in a future bill or in a future action by government. And I would suggest that maybe our committee consider doing the same thing so that we can have an official government response.
Yeah, that's just, unfortunately, that's not debatable. I even was remiss in allowing you to address it. But because there's no debate at this point on that. But I thought you were going to talk about something else. That's why I gave you the floor. So anyway.
Mr. Chair?
Yes.
Because we are moving to a new clause.
You're suggesting we adjourn?
I was going to suggest we adjourn, Mr. Speaker, and come back with fresh eyes, with renewed vigor, and I would move adjournment.
In 2023.
In
2023.
Yes. Well, before we adjourn, I just want to thank our clerk and the analysts and our legislative clerk and the interpreters and the technicians and everyone who makes these meetings possible, and wish everyone the very best for the holidays. Merry Christmas and a very, very happy New Year.
We didn't vote, Mr. Chair.
Pardon? No, I know.
I don't think we'll get any objections.
Yeah, I don't think we'll get any objections, but I just wanted to get that in before we decided to adjourn. So it looks like it's unanimous, Mr. Duguid.
Yes.
We'll adjourn. Meeting adjourned.
Yeah. Okay.